All right. YNW Melly has, through Attorney Raven Liberty, filed a second motion for pre-trial release following mistrial. And the mistrial they are talking about is, of course, because we are up towards the second trial now. Let's see. Boom. So they are arguing that they should let him go. Defendant Jamel Demon's second motion for pre-trial release following mistrial. The defendant, Jamel Demons, buying through the undersigned counsel pursuant to Florida Rules of Criminal Procedure 3.131 and Article 1, Section 14 of the Florida Constitution, and respectively moves this honorable court to set a bond in the above styled cause. As grounds, therefore, the defendant states as follows. Background. Mr. Demons voluntarily surrendered on February 13th, 2019, resulting from a grand jury indictment charging Mr. Demons with 2 counts of homicide in the first degree. Yeah, so 6 years, 1 month, and 10 days ago. A written demand for a speedy trial was made on May 26, 2022, and the jury selection was to begin in the middle of July 2022. However, trial did not occur as demanded due to the state appealing an order of the court striking the state's request for imposition of the death penalty upon conviction. The 4th District Court of Appeal reversed the trial court's decision. The Supreme Court of Florida subsequently denied jurisdiction. On April 6, 2023, the undersigned filed a notice of expiration of speedy demand. A hearing was held April 11th, and the jury selection began hours later. Opening arguments were given on June 14th, 2023. Trial testimony included testimony from various law enforcement, included but not limited to Detective Mark Moretti and Detective Danny Polo. On July 22nd, 2023, Judge Murphy declared a mistrial when the death-qualified jury was unable to reach unanimous verdict as to Mr. Demon's guilt on all counts and set the retrial to begin on October 2nd, 2023. That's a year and a half ago. On October 12th, 2023, the then lead prosecutor, Christine Bradley, was removed after the defense team learned of an all-office conspiracy to withhold Brady evidence. Detective Mark Moretti asking another officer to lie on his behalf. As a result, 3 new prosecutors took over the matter. The court granted the state's request to extend speedy trial due to extraordinary circumstances of the prior prosecutor being removed from the case and the need for added time in order to be prepared. For me, this is bullshit. Why should the defendant suffer because the state fucked up? Why? And it doesn't really matter if you believe he's guilty or not, Mr. Demons. The state still has to follow the fucking law. And if they are unable to, then throw it out. Hold them accountable. The parties began selecting a jury on or about October 25th, 2023. Jury selection was only set on the days that ASA Bucklew was available. The bifurcated process of jury selection was not successful due to the parties sometimes only convening once a week. On or about December 14th, 2023, the state gave notice of their intention to introduce the entirety of Mr. Demon's music catalog and hundreds of hours of jail phone calls of other inmates, along with 2 YouTube videos of 1099 Jake. See here. Jail phone calls of other inmates, meaning it wasn't even Melly who made the jail phone calls. It's insanity. Absolute insanity. On December 20th, 2023, based on the prospective introduction of new evidence while selecting the jury, Mr. Demon's detriment, it was decided that the entire jury panel would be struck. The defense team was forced to withdraw the speedy demand in the homicide matter and seek a continuance of the retrial. Yeah, so the state fucks up and the defense has to suffer. That's Florida for you. That's Florida for you. It was agreed that the parties would begin selecting a jury beginning January 2024. It has now been discovered in the midst of all the delay tactics by the state's attorney's office. On December 13th, 2023, a warrant was issued by Judge Peter Holden pertaining to multiple telephone numbers of the undersigned, including cell phones and office landlines, searching for information regarding Danny Polo and a YouTube content creator who goes by the moniker 1099Jake. If you don't know who is Danny Polo, Danny Polo is the guy in the balaclava, in the ski mask, who testified in the ski mask because he claimed he needed it, and he claimed that there were no pictures of him online. That turned out to be a lie, which meant that because somebody sent the defense, hey, found him, and they objected to him testifying in the balaclava, and he had to continue testifying without one. That the prosecution in this case says that is witness tampering. That they found him, the pictures of him online. They found out he lied. And for that, the prosecution started an investigation of witness tampering and got all of attorney Raven Liberty's iPhone data. Her phone, the iCloud, her laptop, everything. Everything was handed over. And they didn't find out until much later that. So this was a secret investigation by the prosecution. On January 30th, 2024, the state of Florida appealed certain orders suppressing evidence regarding emails, social media, and text messages that were prior to the date of the alleged offense, to wit, October 26, 2018. In addition, the last portion of the promotional video was found to be irrelevant and excluded from evidence. On January 29th, 2024, the court entered an order staying the homicide retrial. On July 15, 2024, an order was entering stating Mr. Demons was in custody for 1,977 days, and his retrial was set for September 10th, 2025. Upon information and belief, it is very unlikely that this matter will be ready to go to trial September 10th, 2025. The defendant has remained incarcerated more than 2,000 days since the date he voluntarily turned himself into law enforcement 6 long years ago. Mr. Demons has, for several years, been the subject of extreme mental abuse at the hands of Broward Sheriff's Office. He has not had any contact with the outside world in 3 years. Mr. Demons remains to this day a lucrative recording artist with streams of incomes. He cannot contact his managers or accountants. As a result, he has lost any control over anything he has. Mr. Demons is not allowed to talk to his younger brother or sister. Mr. Demons has protected and supported both of his siblings throughout their entire lives, but he has improperly not been permitted to speak with them because the Broward Sheriff's Office won't allow him to have any contact with his siblings, not to mention his mother, his grandmother, grandfather, great-grandmother, and friends. Mr. Demons is not allowed to speak to other inmates in the jail, and over a year ago, a sheet was put over his cell door so no other inmates can look at him when they walk by. This is isolation. This is torture. For you, sheriffs of Broward County, this will be your judgment. If you or any of you are Christians, this will be your afterlife. Having litigated several motions in trial court, as well as emergency writs in this honorable court, and having exercised his right to a trial by jury, Mr. DeMons continues to defend his constitutional rights to justice and liberty. Argument. The purpose of bail is not to punish an accused, nor to detain an accused in custody prior to disposition of the case. The purpose of bail, commensurate with the presumption of innocence, is to ensure an accused appearance in court. The constitutional right to pretrial release guaranteed to a person charged with a capital offense or an offense punished by life imprisonment has long been governed by the well-established precedent of the Florida Supreme Court in State v. Arthur. As recently explained by the 3rd District Court of Appeal in Thortman v. Jr., by way of background, the Florida Constitution gives a person arrested for a crime the right to pre-trial release on reasonable conditions such as bond, subject to certain exceptions. The quote-unquote capital or life offense exception applies when the person is charged with a crime punishable by capital punishment or life imprisonment and the state can demonstrate the proof of guilt is evident or the presumption is great. A person held under this exception is entitled to an adversarial, evidentiary bond hearing that examines the state's evidence to determine if it rises to the level of quote-unquote proof evident, presumption great. Accordingly, a defendant charged with a capital crime, such as Mr. DeMons, is entitled to an evidentiary bond hearing at which the sufficiency of the state's evidence may be challenged, and evidence pertaining to his guilt may be presented. See Brackett v. State. Granting the petition for writ of habeas corpus and directing the trial court to hold a new bond hearing, quote, where it shall afford petitioner an opportunity to present witnesses pertaining to all aspects of the bond issue, including whether his guilt is evident or the presumption is great. The long-standing precedent on this issue recognizes that the requisite degree of proof at an Arthur hearing is higher than that of the degree of proof necessary to sustain a conviction at trial, which the state was unable to secure in this case. The State ex relevant egen v. Williams. The degree of proof sufficient to deny an accused the right to bail in a capital case under a constitution is actually a greater degree of proof than that which is required to establish guilt, merely to the exclusion of reasonable doubt. However, even if the state was to meet its odious burden of proving that the proof of guilt is evident and the presumption is great, the trial court is not precluded by this determination from ordering the release of Mr. DeMons upon reasonable conditions. Rather, the trial court still has the discretion to grant or deny bail. See Arthur blah blah blah. If, after considering the defendant's responsive showing, the court finds that the proof is evident or the presumption great, the court then has the discretion to grant or deny bail. Is Sheriff Grady Judd in Broward County? I don't know. I really don't know. The burden is on the accused to demonstrate that release on bail is appropriate, which is to merely establish that even if Mr. DeMons has no constitutional right to pre-trial release on reasonable conditions, the defendant still has the option to provide proving certain facts that permit the circuit court to use its discretion to grant pre-trial release under sufficient conditions. West FSA Constitution blah 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 blah. If, after considering the defendant's responsive showing, the court finds that the proof is evident or the presumption great, the court then has the discretion to grant or deny bail. The circuit court may exercise discretion to grant pre-trial release if the defendants can prove that conditions of release can effectively, 1. Protect the public from the risk of physical harm. 2. Assure his presence at trial. And 3. Assure the integrity of the judicial process. Appropriateness analysis. Nom, 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 nom. It is not permissible to continue to deny Mr. Demons the fundamental right to liberty when other alternatives exist to satisfy any compelling state interest. Mr. Demons voluntarily surrendered as requested on February 13th, 2019. He survived the global event in Broward County Jail to finally go to trial. A mistrial was granted that July, with genuine hopes and a speedy trial demand to start a retrial in October of 2023. That date did not occur through no fault of his own. The lead prosecutor, Christine Bradley, withheld evidence of the lead detective Mark Moretti during the first trial, causing the date to be reset. This misconduct led to Ms. Bradley being removed from further involvement in the case and 3 new prosecutors assigned. There appears to be no end in sight for Mr. Demons. This case has been stayed for more than a year, while the defendant has remained held in unduly strict custody, being abused at the hands of Broward Sheriff's Office and denied access of both the undersigned and his investigator. Corn Pope, I agree. I watched the trial too. They have some serious evidence, which for me is, why did they have to cheat? Why all the misconduct? There was really no need for it. But now you have an officer who asked another officer to lie for him and a prosecutor that withheld that from the defense. That, again, at that point, it should not matter if you believe he's guilty or not. If the misconduct from the state is that severe, it should be thrown out. And it will not be the fault of the defense. You should all blame the prosecution, not Melly. Moreover, there are multiple other motions that still need to be heard. However, if the state takes an appeal every time they are not successful, as they have done on multiple occasions in the past, then Mr. Demons will sit in jail for an unknown period of time before the case can possibly be tried. Mr. Demons is being forced to choose between a fair trial or a speedy trial. Not only has the amount of time Mr. Demons been in Broward County Jail awaiting trial unconstitutional, but coupled with the mental abuse and deprivation of basic human rights, the entirety of the situation is an embarrassment and horrible reflection of the entire legal system and the state of Florida. At this very time, BSO has placed a sheet to cover Mr. Demons' cell so no other inmate can contact him. This abuse has gone on for over 3 years, and when any attempts are made to rectify the deprivation of rights, the defense is always met with there is a quote-unquote investigation. There is no reason to believe that defendant poses a danger to the community or a risk of flight in this case. As such, there is a presumption in favor that the defendant should be released on his own recognizance without the need to post any financial bond. To that end, certain conditions can be set by this court to ensure defendant's appearance at any required court dates and to ensure the safety of the community. Wherefore, defendant Jamel Demons respectfully requests that this court grant the instant motion and order defendant released on his own recognizance. Law Office of Raven Liberty, PA. Now, to be honest, will this happen? No. And the courts have little to no power over how Broward County Sheriff's Office handle their inmates or pre-trial inmates. Yeah, I actually hung out with Jeff during that first trial on a few occasions. I actually did. And that is also why I'm doing the coverage of the YNW Melly trial. Jeff, miss you. Oh, Fedorowski, have you tried the Bländande bottle, which is blend from Van and Smögen? I have not. I can't get old hair, so I might try it. This bottle has 55.5% mix of smoky whiskies from bourbon and sherry barrels. That sounds amazing. Yeah, as Gigi says, the judge can give him a bond. Yeah, they can give him a bond on a few $1 million or many millions of dollars with more or less you're on house arrest, you can't leave your house, there are you have to pay for guards, you will have damn well ankle monitors on both your legs, both your wrists and around your wiener. I mean, they can impose so many restrictions, so many restrictions, because again, it doesn't matter if Mr. Demons is guilty or not, or if you believe he did it or not. Are you okay with how the state handled this? Are you okay with a person who is presumed innocent not being able or denied contact with his mother, with his siblings, with his grandmother and grandfather? Are you really okay with a person being in total isolation? The only people he is allowed to meet is the occasional meeting with his attorney and jail guards. Are you really okay with that? I am not. I am not. All right, let's check what's been happening here in the chat. Arthur Doctor, I've seen stories of not only other minors but adults too being kidnapped and held hostage in Indiana. Yeah, if you have Delphi as the center point and have a 250-mile radius around it, there are so many unsolved murders. It is ridiculous. Absolutely ridiculous. Dun, dun, dun. Is Rick Allen getting any help from any new lawyers? Well, he has his appellate attorneys going through everything now. Tammy, I don't see him getting released. I think the chances are slim to none, but they still have to, because it's a new judge. He might have other ideas. Oh, thank you, Gigi. Glad you're here. Please tap the like button if you haven't already. Thank you so much. Dun, dun. Can he do a habeas corpus? I think he already did. Dun, dun, dun. Malik Parker. This case needs to be tossed at this point. Yeah, I understand why people really are reluctant to tossing a case like this, a double homicide, with this amount of evidence. But again, how much do you want to allow the state to get away with? How much misconduct? There was not that long ago a person who has spent 27 years on death row, and then it was revealed that the lead detective in that case paid a jail informant to make up a story, a confession. So now that person is out of. I'd like to see if I can find it. Texas. This was just a couple of weeks ago. Dun, dun, dun. Here it is. Murder conviction of Texas woman on death row for 27 years tossed by federal appeals court. Prosecutors improperly used the jailhouse informant to help their homicide case against Brittany Marlowe Holberg, the court ruled. That was her 27 years ago. Brittany Marlowe Holberg was convicted in 1998 of robbing and murdering 8-year-old A.B. Towery in his home in Amarillo, Texas. Holberg, yeah. Let's see here. Holberg has always maintained that she ended Towery in self-defense after he started beating her. But at trial, prosecutors brought to the stand Holberg's cellmate, Vicky Marie Kirkpatrick, who testified that Holberg confided that she murdered Towery for the money, court records showed. Holberg denied having ever spoken to Kirkpatrick about the slaying. For frick's sake, Holberg defense lawyers and the jury had no knowledge that Kirkpatrick was a confidential informant for Amarillo police. At the time of Holberg's trial, the state knew about Kirkpatrick's confidential informant work for the Amarillo police, but presented her to the Amarillo jury as a disinterested individual who wanted to do the right thing and was attempting to be as truthful and complete as she could be. According to Judge Patrick E. Higginbotham, writing for the majority in the 5th U.S. Circuit Court of Appeals ruling, which was published Friday. This is a couple of weeks ago. The state did not disclose Kirkpatrick's work as a paid informant until after Holberg was sentenced to death. Holberg's counsel cross-examination of Kirkpatrick spanned only 6 pages of the trial transcript, a reality that speaks volumes. Judge Stuart Kyle Duncan, writing in dissent, argued that Kirkpatrick's testimony played only a small role in the case. Yeah, there's always somebody who makes that claim. Oh, it was only yeah, but and he claimed that so even had Kirkpatrick been impeached, there's zero chance that the jury would have credited Holberg's laughable claim of self-defense or spared her the death penalty for slaughtering a sick old man, Duncan wrote. Oh, you cunt. A sick old man? Oh, yeah. Guy was 80. He was also frequent with prostitutes, a known woman beater, known for many, many things. I believe. Let's see, who is this fucker? Stuart Kyle Duncan. Let's see who this. But for fuck's sake, what's going on here? He's a young guy. Yeah, don't know. Yeah, it's besides the point. The appellate court ruling kicks the case back to trial court. Randall County District Attorney Robert Lowe, previously a prosecutor on the case, said he's disappointed by the ruling, but wow, that this legal action is not over. Robert Love, previously a prosecutor on the case. So you knew too that the investigator paid for the testimony and you did nothing. The Texas Attorney General's office has been handling this appeal since 2010, and they are currently discussing the legal options available to the state of Texas in this case. Lund said in a statement Wednesday evening, "Our office has agreed to not weigh in on the legal aspects of the case until the Attorney General's office has decided their course of action in this matter." Blah, blah, blah. Okay, that seems to be it. So yeah, 27 years on death row because the case the prosecutor and the lead detective believed was so weak, so they paid somebody to lie on the stand. How bloodthirsty can you be that you tell yourself, "Oh, I don't think the evidence will be enough. There might be a chance that the jury will go for the self-defense. Let's see what happens." And the investigator said, I can pay this woman to lie on the stand for us. And the prosecution said, "Good. I will put her on the stand." They were prepared to kill a person with the help of a paid by lying in court. Are you really out for justice then? Or are you just longing to kill without repercussions?